Hello, my name is Jed Strong and I am the owner and founder of Strong Law. Today I wanted to discuss the basics of an auto accident claim and what you should know if you have been in an accident and have an accident claim. So first off, it's important to recognize that each claim is dependent on the state where the accident happens. So the laws are slightly different in each state or each jurisdiction, and so you want to make sure that you're following the laws of the state where the accident actually occurred. So if you're on vacation and out of state, then it's important to make sure that you follow the laws of the state where the accident actually occurred. And so it's important then, if you're talking to an attorney, to make sure that the attorney is licensed in the state where the accident occurred, because that's obviously where they can only practice law. But the basics between the different states are pretty much the same. So first off, the insurance company of the at-fault driver is required to compensate an accident victim for the various losses that they've suffered in a claim. So that would include medical bills, both their past medical bills and any future medical bills, lost wages, both past and future, and any property damage, typically damage to a car, and then also any pain and suffering, both past and future. It's important, however, to recognize that all of those losses and injuries have to be directly related to the accident. So if somebody is already suffering from chronic back pain and you get in an accident and you suffer more back pain, then the insurance company is required to compensate all of those categories that we listed, but only for the areas that are related to the new injury or the aggravation of your pre-existing back pain. The insurance company is not required to compensate you for the fact that you had back pain before the accident. So and that's where many of these cases really come down into the fight, is focusing exclusively on what is related to the accident versus what is pre-existing or what is caused after the fact by other issues. So the three elements that you really need for an accident claim is: one is you have to prove that the other person is at fault for the accident. Two is you really do need insurance available to pay for all of the different expenses and compensations that are needed for those injuries and losses. And three is you have to be able to prove that the injuries incurred were directly caused by the accident. Now, there are a lot of nuances with those three elements. There's a lot of different laws and procedures that can affect how each of those elements interact. And so it can be relatively important to get an attorney, so that way you can make sure that all of those laws and nuances are addressed properly. However, that does not mean that you always need an attorney. I typically recommend that if you are going to require at least a month or more of medical care, so if your injuries are serious enough that you need a month or more of medical care, I would contact an attorney and have them work on your case. Now, that doesn't mean that you have to wait a month before you talk to an attorney and hire an attorney. You can tell pretty easily if it's something that's going to be ongoing, or if it's going to be the pain for a weekend and then it's over. But if it looks like it's going to be more than a month, then I would highly recommend getting an attorney involved. One of the reasons is because every claim in every state has what's called a statute of limitations, meaning that you either have to file a lawsuit or you have to settle your case before that statute of limitations expires. That can be as quick as 180 days in some circumstances, up to several years. I think the longest one I know of is 6 years. So depending on the circumstances of your case, you have a shorter shot clock on when you have to either file that lawsuit or get your case settled. So again, if it looks like you're going to need more than a month of medical care, then I would highly recommend getting an attorney on board early, because it's much easier to have it on board early. That way the attorney can investigate the claim, get all the facts and everything that's needed to present that lawsuit, rather than if you come to an attorney with only a couple of months left before your statute of limitations. Well, quite frankly, my firm usually does not take cases where we don't have enough time to properly evaluate the case prior to filing a lawsuit. So it's, and I'm sure many other firms operate the same way, because it needs to be done properly, and in order to do it properly, you have to make sure you have that time. So if it looks like you need more than a month of care, go ahead and contact an attorney. But going back to the basics of an auto accident claim, so the at-fault insurance company is primarily responsible for compensating the injured victim. Now, every insurance policy has what's called a policy limit. And so when an individual buys an insurance policy, that's a contract or an agreement with an insurance company, and the insurance company agrees to pay up to a certain amount of the compensation that's needed to an accident victim. Well, many times there are accidents that the injuries are more severe than the policy limits allow for. So let's say you get in a serious accident and you have $50,000 worth of medical bills. Well, many insurance policies are only a $25,000 limit. So here the at-fault driver only has $25,000 of insurance coverage, but you have $50,000 of medical bills that need to be repaid. One of the ways that you can go about making sure that those medical bills get repaid is opening what's called an underinsured motorist claim, or a UIM claim. So if you file a lawsuit, if you get in an accident and you settle with the at-fault insurance company for their policy limits, so in this example, $25,000, then you can go to your own insurance company and open a UIM claim, or an underinsured motorist claim, under your own insurance policy. And again, that claim is limited by whatever limits you purchased when you bought your insurance policy. So, and quite frankly, some people even waive their UIM coverage, trying to get a little bit cheaper premium. They waive their UIM coverage, which I think is a very foolish decision, because there are so many accidents where the at-fault party doesn't have enough insurance to cover the injuries. So I recommend that you make sure that you have at least $100,000 of UIM coverage on your policy. So that way, if you do get in an accident where the at-fault does not have enough insurance to cover your injuries, you have at least $100,000 from your own insurance carrier to make sure that you can get fully compensated, get all those medical bills paid, lost wages, pain and suffering, all of it through the different insurance policies. So that would be a second step in a UIM claim, in an accident claim. First, you go against the at-fault driver's insurance, then you can go against your insurance. Another aspect of these accident claims, and it depends on the type of insurance policy that you purchased, but you are, in most states, you're able to purchase what's called personal injury protection, or PIP coverage, or in some states it's called MedPay, and that's through your own insurance carrier. So if you have that on your policy, you would want to use that coverage to pay for any of your medical expenses immediately following the accident. I mean, some states have really low coverages, like Utah, for example. I think the minimum is $3,000. Other states have much higher coverages. The minimum in Oregon, for example, is $15,000. But that is a certain amount of money from your own insurance company that goes to paying primarily your medical expenses immediately following the accident. It can also pay for some of your lost wages. So check your policy. If you have that PIP or MedPay, you'll use that portion of your policy to pay for your medical expenses at the beginning. And then on the back end of the case, once everything's all resolved with the at-fault insurance carrier, they will then reimburse your insurance company for those premiums already paid. For those expenses already paid to your medical bills or lost wages. So that's kind of the running summary of an accident claim. You first go after the insurance company, the at-fault driver, and then you look at your own insurance company to see what different coverages and benefits you have available to you under your policy. So hopefully that points you in the right direction. Please take a look at our other videos talking about some of these issues with more specificity and some of the nuances in the different states.